I was gonna say they must have gotten the notices. I noticed that too. Yeah, it's like old. I would like to call this meeting session. We're here today with the Planning Commission. It is Thursday, June 12th, and we will start out with a prayer. Member Telford, do you want to give a prayer? And after Commissioner Telford gives the prayer, please join me in rising for the Pledge of Allegiance.
Greatest night for guidance, hope, and strength.
Moving on to the approval of the agenda, do I have a motion to approve the agenda for May 8th, 2025, our Planning Commission minutes? Got a motion from Member King, second from Member Wilson. All in favor? Any opposed? Motion carries unanimous. Declaration of any conflict of interest. Any of the items on the agenda tonight? Seeing none, we'll move into public comment. Our legislative item will have a, no, it won't. Public hearing, yeah. You were just giving me a look, okay. Nope. No, I was saying we'll have a public hearing. Anything administrative on the agenda? Seeing there's none tonight, we will close public comment.
Thank you, Madam Chair, and good evening to the members of the Planning Commission. Regarding the Ponderosa subdivision Phase 2 preliminary plat, staff is still awaiting a new set of engineered drawings and some documents regarding the water for the subdivision. Staff hasn't received those items, so when we do receive them, it'll trigger a period of review, and then we'll bring it back to another meeting. But for now, we're asking for this item to be continued to July 10th.
Any questions for staff? Thank you for noticing it. I think that helped tonight.
Do we need a motion to?
Okay. Okay, so July 10th, perfect. Do I have a motion to continue the Ponderosa subdivision preliminary plat to the July 10th, 2025 meeting?
Motion.
Motion, Member Watt, second, Member Telford. All in favor?
Aye.
Motion carries unanimous.
Several months ago, the County Commission had two presentations on separate nights regarding cemeteries and the lack of cemeteries within the county that have room to house deceased individuals. At that time, they directed staff to propose changes to the cemetery text that we have, which is it's fairly non-existent. There were a couple definitions, one for private cemetery, one for public cemetery, and then the land use sections included in the agriculture or large acreage properties. There were private and public cemeteries in there. And then in the commercial sections, it also included the ability to have public cemeteries. Private cemeteries were absolutely prohibited. as I went through it and consulted with our attorneys and looked at other communities and what they were doing, some of the other communities that we looked at, Salt Lake City, I believe I looked at Sandy and a couple others, they were overly complicated. They didn't really address any design standards, anything like that. So I didn't really use a lot of those. I kind of formulated this myself and then drafted it with the county attorney's help. Private cemeteries in the state of Utah are allowed. They would be a privately owned organization who would run that cemetery in perpetuity. But there's also government-run cemeteries, and so I thought we could get rid of the definitions for private and public, combine the definitions into a single definition, and then delete private cemetery out of the land use tables and just call it cemetery. Leave it with a C3, which is a county commission approval, and then the cemetery approval standards followed. I wrote this several weeks ago. It sat for a couple weeks. I reread it today. Early this morning, I was going to go through it trying to prepare my presentation, and I noticed some Scrivener errors and a few other things that I think need to be clarified and changed with the original draft. And I can just go through those quickly. The substance itself is not changing, but these are clarification things that I think need to change. So in section A, it says site plan, the planning commission. First off, it's more of an application. And so I want to change the site plan to an application, and that application needs to be submitted to the county and needs to be complete. And then that application would include a preliminary and final plat. It would include a site plan, a landscape plan. So nothing else changes. It's just calling it out as more of an application as opposed to doubling up on site plan. So site plan is actually one of the submittal requirements. So I saw that I missed that. With that change, the planning commission is not the deciding body for a site plan anyway. It's the county commission. They're the land use authority. And so that would have been a mistake anyway. So the application needs to be submitted to the county. The county will review it, and then we'll take it through the C3 process, which is exactly what the site plan follows anyway. It's not a conditional use permit, but it still goes to the county commission. Another clarification in B4, it says the location of areas covered in the event of a base flood. I don't think I finished the sentence there, and so I've reworded it. Like I got interrupted in the middle of a thought, I think. What it should say is the location of areas covered by the floodplain with corresponding base flood elevations. What we want them to show on whatever map or site plan that they have is that there are areas of the property that cannot house caskets or entombed individuals because of floodplain, steep slope, things like that. And so those areas need to be denoted. And if there is a floodplain, then really their engineer, when they're creating the site plan and the plats, should denote the base flood elevation so they can make sure that whatever they construct there is outside of the base flood elevation, and that no bodies can be placed in those areas. C3, I'd like to add just an additional sentence that states these areas shall be noted on the plat, which kind of ties into B4. The potential for flooding, high topographic relief, shallow depth to groundwater, things like that. Those areas need to be denoted on the, not just the site plan, but on the plat, because it's the plat that's recorded. So when we're processing applications, things like that, we typically pull the plat and we look to see if there's any restrictions on that plat. So I'd rather we have a recorded document that shows it as well, so that we have access to it quickly. And then C6, I would just like to denote that the 12 feet is for one-way traffic only. That if they want it to be a two-way traffic, it should be 24 feet for passing vehicles. So just to clarify the distance there. The only other change, there's two There's two changes. I'd like to add a 6 to D that states existing vegetation may be counted towards the total required trees and shrubs. There's a lot of vegetation on some of these properties in the county, and I'd rather we maintain and preserve existing trees and shrubs that are there that are natural vegetation as opposed to wiping an entire site and then replanting. I think that would be irresponsible. And then F, again, it shouldn't be the planning commission, it should be the county commission because they are the deciding body for a C3. So that's just a little section that I missed. Other than that, everything else that I've provided and written, I'm requesting that this be recommended approval for, and then we can take it to the county commission and get this into our code. The attorneys have reviewed it. I believe it meets state statute requirements, and it provides us more direction for companies or individuals that want to create a private cemetery, or even if the county wants to get into the cemetery business. There's quite a few jurisdictions that do that. Thank you. Questions, comments?
If you combine, curious if you combine them together so that it's just one cemetery in terms of definition, does the county, if they wanted to get into the business of doing that, would they have to apply like to itself? You go through the application process?
Well, technically, the government doesn't have to comply with the rules and standards that they've adopted. That's Supreme Court law. Typically, it's a good idea for them to follow the rules that we set out. They wouldn't necessarily submit an application. That'd be like the left hand submitting an application to the right hand.
Yeah.
It's not necessary. Combining the definitions together opens it up for private individuals or organizations to actually run and have a cemetery here. There's provisions later on in the text that require them to post a certain amount to make sure that they have the funds to run it in perpetuity.
Thank you.
So, this, but with the additional changes that you've just discussed is what you're asking for. So should we be even approving this tonight, or should we have you come back with the changes you wanted to make?
No, you can make a recommendation tonight, and then I can take that forward between now and the county commission meeting. I'll make the minor changes that I'm requesting because the substance hasn't changed.
Okay. I mean, I would, if it was one or two little words, it'd be one thing, but there's a fair amount of change there. So, all right.
The number of changes related to, instead of calling it a site plan, we're calling it an application because the site plan is required. There's a couple word changes and a couple sentences that were added in for clarification purposes only. I don't think they're major enough that I should have to bring that back.
Additionally, to piggyback, there is some state law code regarding and controlling cemeteries, and the state law incorporates municipality-owned cemeteries into it. So there are still some regulations like recording a plat and things like that. Not a ton of them.
So by combining this, does this make Morgan County kind of unique in the state, the way you're laying this out?
Well, I think it's written better than some of the others I've read. If that's
Well,
what you
yeah,
mean.
I'm all for streamlining. I'm just wondering that this is not, I mean, this is very streamlined.
Yeah. I think it reads well.
I kind of like it.
Does the motion then need to be just with the additional verbal changes that you described here?
That's correct.
Okay.
And I have them written down. I can change those, make those, and then bring those back to the county commission so they have a
Yeah.
document.
Go into no more discussion. Maybe we'll go into a public hearing. Do I have a,
Going into a public hearing doesn't necessarily mean that there can't be more discussion later.
totally. I'm just saying, is that a good time to go? Yes. Do you have a motion to go into public hearing? Motion, Member Wilson. Second, Member King. All in favor? Motion
Aye.
carries unanimous. Seeing no comment, do I have a motion to go out of public hearing? Motion, Member King.
Second.
Second, Member Watt. All in favor?
Aye.
Unanimous. We are out of public hearing. Any more discussion on that?
I'd like to make a motion that for recommendation for approval with conditions, I move we recommend approval to the County Commission of the Cemetery Code text amendment based on the findings listed in the memorandum dated June 12, 2025, with the following additional conditions, and that is the changes as they were put forth in a narrative to us this evening.
A motion by Member Watt, a second by Member King. All in favor?
Aye.
Motion carries unanimous. $15. Moving on to business and staff questions.
Yep. Okay, so staff has been having some problems making sure that we have a quorum. And I know that a lot of us don't, it's your county email, which these things get sent to, isn't the number one email that you guys are looking at. But I just want to make sure that we avoid some problems, particularly for you, for the county, and for me, so that I don't end up with more work. We've had this problem with another department that utilized their personal cell phone for communication. And so I just want to remind you guys to be careful. Per our bylaws, specifically section E1, if a commissioner is not going to be able to make it to a meeting, you need to contact Judy. And I'd recommend doing it via your county email so we can trace it. And if there's any grandma requests, we can keep up with that. Lately, Judy's had some problems getting emails back confirming if people are going to be here. And I know Chairman Maloney stepped up and texted people, which was nice. But again, I highly recommend using the email. We run into problems under a couple things. One is the Open Meetings Act. And so like discussing quorums, agenda items, or just even informal discussion via text, that can open you up to a grandma request. And I've dealt with that with another department that used their cell phone for business related stuff, and under grandma, we had to pull that. And having been a person that's been in depositions where a public official's personal cell phone, and we've had access to all their records, it can be quite embarrassing and everything if your personal stuff is on there. There was a 2019 decision with the SRC, the State Records Committee, in which, you know, text messages on personal cell phones between members of a board, they were required to disclose those under grandma. So it just, if you can use the county email, that makes it so much easier and keeps you safe, keeps me with less work and everything like that. Additionally, by using the county email, it makes it easy for Jeremy to pull those records, because then he can just pull your county emails for that if there is a grandma request. So just to make sure, if you're not going to be able to make it, email Judy or contact Judy somehow directly per our bylaws. Be careful about any text messaging. If you can use the email, that's great. And if it's that you have a hard time checking that county email, maybe set a reminder, get it on your phone or something that you're checking it. Like, I think the packets come out on Thursday, so maybe a reminder to check Friday, and maybe another reminder the next week that whether or not you're going to be able to make it. So with that, do you guys have any questions about that? I know I sound like I'm beating a dead horse and being mean, but I'm not. It's just, I don't want any of you to get in a position where you're having to use your cell phones, your personal cell phones, are being discoverable.
I have a question. So then is the expectation that we need to email every week we're going to be here? Because that's how it seemed via the email versus, hey, we're just going to email when we're not going to be here. Because those are two different things.
I think that Judy, when she sends out the packet, she asks if you're going to be there. I would leave it up to Judy, because she is the contact per our bylaws. How do you want it done? So.
Okay.
So once I get the packet, if they can just respond then, and I'll be there. Yep. So. Yeah.
Well, I think I was under the impression, and maybe I'm wrong, that that was when we did reach out, right? Like if we weren't going to be here, I haven't historically emailed or called, and maybe I should be. Hey, I'm going to be here this week. Does that make sense?
Yeah, it's just been because of the last couple times where we didn't know who was showing up. So it's just better, when I send out the packet, it just was not that heavy.
Yeah, I think we want to do it both ways because of the last 2 or 3 meetings, we've really struggled to get a quorum. Once we didn't have a quorum, and then the last meeting we didn't have a quorum either, to the point where we didn't even meet. So we really need to let us know. And then if we can get into, I guess, the habit, then maybe we can relax a little bit, but we do need to know who's going to be there so we can plan. Thanks.
As long as I think everyone knows that expectation. I just don't think that was maybe made clear, which that's all.
Yeah, I don't know that that was conveyed. So, yeah, thank you guys.
Chair, can I address? This is a question for Josh. And I don't mean it to be a critique or anything. I've seen this on the agenda probably 4 times, the Ponderosa. And I guess what I'm saying to you is I like it when people respond and come to these meetings. And I feel like this just kills it every time it's put on here and it's canceled.
It has to be put on if it's continued to a date certain. So it's automatically put on for that agenda, which means I don't have to spend money, county money, to re-notice it. Every time it's continued, it has to be put on. If the applicant doesn't give me what I need, then they have the right to request that it be continued again. So I don't know what to tell you.
I know your math on it is what you have to do. I get that part. I'm just telling you back, people have responded and come to these meetings and they've been sent back home. It's renoticed. I think that should be addressed one way or another, what we're doing with it. It just kind of quells anyone's interest in public things.
Well, I tried to address that by posting notices on the door as well as on our website several days in advance. I can't change state statute. I can't change what's allowed. The issue here is, on top of it, is that this is an administrative item. And as long as they meet all of our minimum code requirements, it can't be denied.
That's fine. I'm not arguing that with you, Josh. What I'm saying back is when we notice it, and people take the time to respond, come here, we should have at least a courteous response to them rather than just saying, we're just going to postpone it again.
Yeah, I don't remember being rude.
I didn't say you were.
Well, you implied it. So I've been courteous. I've tried to meet the needs of the public. I've apologized for the applicant. But at the end of the day, this is kind of how public meetings and public hearings can go. It's unfortunate when it does, but I can't change it, and I'm not planning on changing
I wasn't asking you to change it. I'm telling you it doesn't look good. Is there something we can do to alleviate it? Not really.
I don't know.
That's what I wanted to know.
I have a question. Are we confident that they will be ready by the July 10th meeting? Because that's my other thing is like we keep doing this, and I know it's like $400, right, to renotice it. I know it's not cheap. I recognize that. But if it's going to be October and we just keep pushing it every meeting, does that is when you're like, hey, we know that they're going to be here next week, they're ready, we have everything from the engineer, does that make more sense? I know we pushed it today, so it's done for July, but
that's kind of why I pushed it to July instead of the 26th. I think it's going to take a couple weeks to even review what they provide. So I'm hoping they can get it to us by next week. I'm setting up a meeting to talk with the applicant by Wednesday of next week. Hopefully they'll have the documents and our contractors can review that. But I have no guarantee. And at some point I am going to have to just say, look, we're not going to continue it again, but that's going to have to be my call. I think in good faith, we've done right by this applicant, and given who this applicant is, I think it would be better to treat it this way.
But shouldn't all applications be treated the same way?
That's true, and
Like
I have brought
fairly.
every other application forward the same.
I'm
And I've
just
requested-
given who this person is. That's my only comment. Cool. I have a question. Do we have an update on the Ridgeline Protection Code? I think we voted on it in September.
Yep, I have not even started working on that one. I've got about 15 others that are probably going to take precedent over that.
Any other questions, or I'll keep going? I had a question as well about our ADU code, and this is I've been asked a question. I just wanted to clarify and get your thoughts on this. It's my understanding that if someone builds an ADU in our code, there's nothing that prohibits them from then reversing which house is primary and which house is the ADU.
Yeah, I'm not going to enforce which one they call the primary and which one they call the accessory. If they want to build a new house and that house meets all the standards of our code and the existing home is no greater than 75% of the new primary, I don't care and I don't want to enforce that.
Okay. Is that in line with other typical ADU codes?
Yep, and the ones that I've written.
Okay. Legally, is that not a good thing to enforce, or you just
Legally,
don't
I
think-
would rather not even get into that. If somebody owns property, I think they should have the property right to determine if they want a bigger house than the accessory that's the primary that's already there. And if that's the case, they can build a bigger home and the old one can be the accessory. And as long as it meets the other standards of our code, then as far as I'm concerned, that's how it's gonna go.
I've got comments, I guess. Janet, in a legal term, who runs this show? Who's the boss here?
The boss of the planning commission? Well, the members of the planning commission.
Because it doesn't sound like we have much say in it. We're getting told what we will and won't do. Does that not seem odd?
Well, I think as far as Josh is concerned, as the zoning administrator, he's the interpreter of the code as well as the state laws regarding land use. So when it comes to interpretation of the code and how he is, whether he's going to enforce it or how he interprets whether it's legal or not or how to enforce it, that is solely on him. The planning commission, when applications are brought forward to it, legislative or administrative, then this is when you guys are running the show.
So about the discussion I just had with Josh, what's your general comment on that?
I think part of the problem with this is that there's been a lot of things that have occurred with this particular application. It is the prior developer
Now, that's,
worked.
if I may
Yeah.
excuse,
Yeah.
what I'm asking you is it odd to have the professional planner tell us what we can and can't do on things? Does that not, of all the things he said, how many of those would you say, I don't think that's probably accurate or that's not correct?
What
Any
do
of
you
them?
mean as far as can and can't do what?
Well, he's telling us what we can and can't do here on things, what he will and won't enforce. So I'm just curious, is there anything there that you saw that was questionable in your mind?
As far as enforcement and bringing the applications forward, that's on the zoning administrator. As
So
far as
he's our
moving
boss then and tells us what will and won't come
it.
here.
He is not your boss.
That sounds what it
Once he
sounds
brings
like.
it forward to you, then, yeah, he is not your boss. You know, and maybe what we need to do is, maybe schedule a work session to kind of go through all of this and maybe get some things out.
He's fine.
I think that would be a good idea. So if I understand the, being a new kid, but if I understand the process, he evaluates all these applications against codes, state laws. then it goes to you for review
Nope,
before it comes to us?
nope. He's the sole person bringing it forward. I'm just here to help with legal guidance. I am not zoning or code interpreter.
Legal guidance as to what?
As to, so he interprets the code. I will double check and make sure it's consistent with state law as well as case law that might be interpreting it and changing it.
So you have a review. You check
I
something.
don't review the actual applications. It's more like,
No, to cover the county and the liability that could come from any interpretation that I make of the code, I consult with the attorneys to make sure that my interpretation is consistent with state law and state interpretation.
And that's all I'm
Yeah,
trying to verify here is so that by the time it comes here to us, right, it's been inspected. You're not unilaterally doing these things yourself.
No,
You're
that's
following
correct.
codes, ordinances, and if you have question about your interpretation, the attorney steps in. By the time it comes to us, it's been reviewed substantially against those laws.
that's correct.
And as far as individual whims as to likes, dislikes, changes, those don't fall within.
No, I don't have any authority to do anything individually on a whim.
Okay.
That would be illegal. It would open me up to personal liability and personal lawsuit. I'm not about to do
Correct.
that.
That's my understanding. Thank you.
I'm done, Madam Chair.
Okay. Let's go back to the agenda. I'm familiar with the code, it just doesn't say where if the ADU can be swapped, but there's nothing. Here we go, this isn't a touchscreen. Can we go back to the agenda on our computers? Thank you. I need an approval of the May 8th, 2025 Planning Commission minutes. A motion to approve, rather. Motion. Member King, second. Member Telford, all in favor?
Aye.
Carries unanimous. Motion to adjourn.
So moved.
Member Wilson, second. Member King, all in favor?
Aye.